And no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance.
Right. 37 words.
Just 37 words.
It really is, it remains one of the most efficient pieces of legislative drafting in modern history. Like one single sentence carrying the absolute weight of a societal restructuring.
It is wild when you actually read it out loud. Because, you know, those 37 words are famous for putting women on the Olympic podium.
Oh, absolutely.
When you hear that specific phrasing, the immediate mental association for most people is like college soccer field or a basketball court or maybe a high school track team.
Yeah, you think of sports. That is the cultural shorthand we have for it.
Exactly. But today, our mission on this deep dive is to explore the massive silent revolution that those words sparked in the classroom, not on the playing field.
Because the actual target of this legislation was the operating room. It was the corporate boardroom.
The judge's chamber.
Yes, the judge's chamber. Because, and this always shocks people, the text of the law itself never mentions sports. Not even once.
Wait, really? It doesn't say anything about athletics at all?
Nothing. Zero. The most famous sports legislation in American history is, fundamentally, a bureaucratic education law.
That is fascinating. So the athletic applications were, what, just an accident?
They were essentially a byproduct, like an afterthought in the legislative process. The original intent was entirely focused on the mechanics of professional and academic credentials.
Okay, let's unpack this. Because today, we're going to uncover how this one law completely reorganized who holds American credentials, from doctors to lawyers to the people standing at the front of the classroom.
And we really need to look at the stubborn gaps that still remain in technical fields today, too.
Right, the STEM gaps. We will definitely get into that. And the deeply nuanced debate about what it actually means when educational dominance doesn't automatically translate to economic parity.
It is a complicated legacy, for sure.
It is. So for you listening right now, I want you to think for a second about your doctor. Think about your lawyer or maybe the architect who designed your office building.
Just picture them in your head.
Yeah. The person sitting in those chairs today, the person holding that degree and that authority, was fundamentally re-engineered by the policies we are about to explore.
Because this isn't abstract history.
Not at all. This is the deeply relevant architecture of the world you navigate every single day.
We are looking at a complete inversion of the credentials of power in this country, and it happened over the span of a single generation.
Which is just incredible speed for that kind of societal change. So to understand the mechanics of how massive this shift was, we really need to establish the baseline reality of the American educational pipeline before June 23, 1972.
Right, the day those words were actually signed into law.
Exactly. We need to look at the legal and institutional structures that were functioning in, say, 1970. Set the stage for us. What did it look like?
Well, if you walked into a medical school or a law school in the United States in 1970, women made up only about 9% of the students.
9%. That is, I mean, that is single digits.
Single digits. And that figure is so crucial because we have to understand it wasn't a natural equilibrium.
What do you mean by natural equilibrium?
Like, it wasn't due to a lack of ability or a lack of interest or some shortage of qualified female applicants. It was the direct result of strict, informal, and sometimes explicitly formal quotas.
Wait, formal quotas, like written down?
Oh, yeah. Admissions committees at prestigious institutions unapologetically reserved the vast majority of their slots for men.
That is just, I think we tend to think of historical discrimination as this sort of subtle, unconscious bias.
Right, like an invisible hand pushing people away.
Yeah, exactly. But you're saying these quotas were often written directly into the admissions philosophy of the universities.
They absolutely were. They were operating on a very specific mid-century economic logic. It was all about the perceived return on investment for a medical or legal degree.
Okay, explain that logic to me. How did they justify it on paper?
Well, admissions committees viewed a seat in a medical school as this incredibly scarce societal resource. The prevailing institutional logic was that if you gave that highly coveted seat to a woman, she would inevitably get married.
Ah, okay, I see where this is going.
She would get married, have children, and drop out of the workforce.
Right.
Therefore, giving her that highly subsidized, incredibly expensive medical education was deemed a waste. Literally a waste of a seat that could have gone to a man who would theoretically practice medicine for 40 uninterrupted years.
Wow. So they were essentially enforcing a structural family wage model right through the university admissions office.
Precisely. They were acting as the absolute gatekeepers of the professional class.
Using demographic assumptions to filter the applicant pool before anyone even looked at a transcript.
Or an entrance exam score. The system was deliberately built, and I mean meticulously maintained, to keep women out of these specific high-paying professions.
That is incredibly frustrating to even think about.
It is.
And this brings us to the deeply personal rejections that fueled the women who actually built the legal architecture to dismantle those quotas.
Yes, the architects of the law.
Because to understand the law, we have to look at Congresswoman Patsy Mink of Hawaii. She is the lead author of the 1972 Education Amendments.
The statute is actually formally named the Patsy Mink Equal Opportunity in Education Act.
Right. And her trajectory is just a fascinating study in how localized personal friction with the bureaucracy can ignite this massive systemic change.
It is such a powerful origin story because Mink did not start out with the ambition to be a lawmaker. She didn't want to go to Congress originally.
What did she want to do?
She wanted to be a doctor.
Really? I didn't know that.
Yeah. In the late 1940s, she applied to roughly a dozen medical schools, and she received a rejection letter from every single one of them.
12 schools, 12 rejections.
Every single one.
Yeah.
And the rejections were not based on her academic record. She was brilliant. They rejected her explicitly because she was a woman.
They just said it outright.
They did. Those letters of rejection were artifacts of that exact quota system we just outlined.
So the schools either already had their arbitrary handful of women,
Right, maybe 2 or 3 in a class of 100.
or they just simply didn't admit women at all.
Exactly. So Patsy Mink, who was ambitious and academically highly qualified, found the door to the medical profession legally and structurally bolted shut.
Just a total wall.
Yeah.
How does an individual even process that kind of absolute systemic wall? I mean, if the institutions that grant the credentials refuse to evaluate you on your merits, you have to find a way to alter the institutions themselves.
Which is exactly what she did. She pivoted. She took that rejection and channeled it into a totally different vector of power.
Since medicine refused her entry, she applied to law school.
Yes, she navigated the legal profession, eventually ran for Congress, and she brought that lived experience of bureaucratic discrimination directly to Capitol Hill.
She understood it in her bones.
She understood on a visceral level that as long as university admissions committees could legally operate these quotas, women would never achieve economic or professional parity.
She recognized that the barrier wasn't a lack of female ambition. It was a structural lack of federal regulation.
But writing and passing a sweeping civil rights law requires immense legislative momentum. One person can't do it alone.
No, she needed a coalition.
A highly strategic, broader coalition working from multiple angles to really force the government's hand.
Which means we have to bring in Bernice Sandler and Edith Green. Because the way they engineered this momentum is basically a masterclass in exploiting bureaucratic leverage.
It really is. Bernice Sandler is often referred to as the godmother of Title Nels.
I love that title.
It fits perfectly. And her entry into this fight started with a very common, frustrating academic grievance.
Okay, tell us about Sandler. What happened to her?
Well, in 1969, Sandler was a part-time lecturer at the University of Maryland. She was finishing her doctorate, and she was repeatedly passed over for full-time faculty positions.
Despite having the qualifications.
Right. And the justification she was given was notoriously subjective. She was essentially told she came on too strong for a woman.
Wow. There it is. The classic double standard.
Yeah. Assertiveness is rewarded in one demographic and heavily penalized in another.
But instead of just accepting the rejection and moving on, Sandler started digging into the administrative rules, specifically the rules governing federal funding.
And this is where the story shifts from just a personal grievance to a weaponized legal strategy. Sandler discovered a footnote.
Footnote, literally a footnote.
Just a footnote regarding an obscure executive order. Executive Order 11246, which had been amended by President Lyndon B. Johnson to include sex discrimination.
Okay, and what did this order actually do?
It prohibited federal contractors from discriminating in employment.
Federal contractors.
Right. And Sandler realized something profound. Universities are massive federal contractors.
Ooh, oh, that is brilliant.
They receive millions of dollars in federal research grants for defense projects, scientific research, institutional support.
So she recognized that the university wasn't just this untouchable ivory tower. It was a vendor.
A vendor to the federal government.
And vendors have to follow the procurement rules.
Exactly. She connected the dots. If universities were federal contractors and federal contractors couldn't discriminate based on sex, then the systemic hiring practices of higher education were in direct violation of federal contracting law.
That is an incredible legal loophole to find.
So she teamed up with the Women's Equity Action League. And without a massive legal team, they just started filing formal contract compliance complaints.
Against who?
Against hundreds of colleges and universities across the entire country.
Hundreds of them.
Hundreds. They demanded that the Department of Labor investigate these institutions and threatened to freeze their federal research funds.
She went right for the wallet.
She paralyzed the funding stream. She used the federal government's power of the purse to force the issue of academic discrimination onto the desks of university presidents.
Presidents who, prior to this, probably didn't care at all about part-time lecturers.
They didn't even know her name before this. But the leverage was immense. A university might ignore a complaint from a single female academic, but they absolutely cannot ignore a letter from the federal government threatening to withhold millions of dollars in physics and engineering grants.
I can just imagine the panic in those administrative offices.
Sandler's campaign created a massive administrative headache for both the universities and the federal government, which suddenly had to investigate all these claims.
So you have all this administrative chaos bubbling up, and that perfectly sets the stage for Congresswoman Edith Green of Oregon.
Yes, Edith Green was essential.
Because she chaired the Higher Education Subcommittee of the House of Representatives, and in the summer of 1970, she initiated 7 days of congressional hearings.
Utilizing the exact momentum from Sandler's compliance complaints.
Right. And the strategy behind these hearings was so brilliant in its subtlety. Green didn't heavily publicize them as this massive feminist crusade.
No, because that might have triggered immediate organized opposition from conservative lawmakers.
Exactly.
Yeah.
She framed them as standard subcommittee oversight hearings on higher education, just routine government business.
Boring administrative oversight. But under that cover, she brought in educators, lawyers, activists, and researchers.
Including Bernice Sandler.
Including Sandler. And they rigorously documented the widespread sex discrimination happening in university admissions, in faculty tenure, and in vocational programs.
They were constructing an undeniable public record. Because when you want to pass a law that fundamentally changes how institutions operate, you can't just rely on anecdotes.
You need paper.
You need a congressional record filled with data, sworn testimony, and irrefutable evidence of a systemic problem.
And they produced a 1,200-page record.
1,200 pages.
They painstakingly documented the quotas in medical and law schools, the unequal pay for female faculty, and they heavily segregated vocational tracks in high schools.
So this record laid the unshakable legal foundation for the modern admissions rules we take for granted today.
It proved to the broader legislative body that discrimination wasn't just a few isolated bad actor institutions. It was the standard, formalized operating procedure of American education.
Okay, so the original legal complaints gathered by Sandler, combined with the hearings orchestrated by Green and the legislative drafting by Mink. This shows us that Title IX was born out of profound employment and admissions grievances.
Yes, adult women fighting for their careers.
Adult women fighting for their salaries and their right to learn years before the law ever touched a high school athletic budget.
It was a bureaucratic siege on the institutions that control the entryways to the middle and upper classes.
Okay, but while this massive battle for elite graduate school admissions and faculty tenure was being fought in Washington, D.C., the most universal daily experience of sex discrimination wasn't happening at the Ivy League level.
No, it was happening in the high school scheduling office.
Exactly. Here's where it gets really interesting. The battle for elite degrees affected thousands of people, sure, but the vocational tracking system affected millions of teenagers every single semester.
Right, because the elite admissions quotas capped the top of the professional pipeline. But the vocational tracking system severed the economic pipeline at the high school level for the vast majority of the population.
We're talking about a highly formalized system where girls were systematically forced into home economics, while boys were sent to woodshop, auto shop, and machine shop.
And we have to be clear, this wasn't just a gentle suggestion from a guidance counselor based on a student's hobbies.
Right. It was a hard, non-negotiable rule mandated by the curriculum structure, like entire specialized public vocational high schools, schools dedicated entirely to automotive trades, aviation mechanics, maritime skills, drafting. They were strictly reserved for boys.
A teenage girl literally could not enroll in the building.
The doors were locked to her based on her gender.
And to understand the gravity of this, you have to look at the economic function of vocational education at that time.
How so?
These programs were heavily supported by federal funding, dating back to laws like the Smith-Hughes Act of 1917. And that act explicitly categorized vocational training along strict gender lines. Vocational education in the mid-20th century was the direct state-sponsored pipeline to unionized high-wage trades.
Right. So by barring young women from auto shop or drafting or aviation programs, the public school system was actively deciding who would have access to the middle class.
They were relegating women to lower-paying domestic or clerical roles.
The state was determining your economic destiny based entirely on your gender.
And the counseling apparatus in these high schools acted as the gatekeeper for this economic sorting. It wasn't just the physical classes, it was the entire psychometric infrastructure.
The psychometric infrastructure, you mean like the standardized testing?
Standardized testing, aptitude tests, school counselors actively nudging girls away from advanced math, spatial reasoning, hard sciences.
The aptitude tests themselves were literally color-coded, right, and normed differently.
They were. Tests like the Strong Vocational Interest Blank had completely different versions for men and women. They were often printed on pink and blue paper.
Pink and blue paper. You cannot make this up.
If a young woman took that test and showed a really high aptitude for logical reasoning or mechanical comprehension, the counseling materials would interpret that score to steer her toward becoming a dental assistant or a clerical worker.
But if a young man had the exact same score...
If he had the exact same score, he would be steered toward engineering or industrial management.
That is wild. The testing instruments were biased by design.
By design. They channeled women into what the state deemed appropriate low-wage fields like cosmetology or allied health, while actively training and counseling boys to pursue higher-wage trades and leadership tracks.
So the counseling office was basically the bureaucratic enforcement mechanism for the social norms of the era.
They presumed that men were the primary breadwinners and women were just temporary members of the workforce whose primary ultimate function was domestic.
But Title IX fundamentally ruptured that pipeline. When the law took effect, it made this kind of sex-segregated tracking in federally funded education completely illegal on paper.
Overnight, a school district could no longer use federal money to run an aviation high school that refused to admit girls. Nor could they force girls to take home economics while barring them from drafting classes.
The practical reality of this is staggering. Think about it. Suddenly, in 1973, a 15-year-old girl could walk into her high school scheduling office and sign up for auto shop, or advanced calculus, or machine shop.
Without a school policy standing in her way.
The transition from vocational tracking to modern professional disparities all traces back to who was allowed in the room when the fundamental skills were being taught.
The change looks subtle, just a few lines of text in a federal statute. But in the life of that teenager, it was an earthquake. It connected early educational access directly to lifelong economic outcomes.
We often separate education from economics, but Title IX forces us to see that the high school scheduling office is a primary engine of wealth distribution.
Absolutely.
Okay, so getting into the right class was only the first hurdle. Having the legal right to actually stay in school when real life happened was the next massive shift in the daily educational experience for young women.
This is a huge part of the story.
It is. And it brings us to one of the most consequential but honestly least discussed clauses of Title IX. We are talking about the protections regarding pregnancy.
The pregnancy provisions fundamentally dismantled the concept that a young woman's education was conditional upon her perceived moral standing.
Because before 1972, the policy in countless school districts across the country was incredibly punitive.
Very punitive.
A teenager who became pregnant, or in many districts, even a teenager who just got married, could be legally expelled.
Expelled.
They were quietly pushed out of their school district, and there was absolutely no federal law to stop it.
It was standard operating procedure. It was rooted in this legal doctrine called in loco parentis, where the school acted in the place of the parent as a moral guardian.
A moral guardian.
Right. And the administrative philosophy was one of moral contagion. The belief was that a pregnant student, or even a married teenage girl, would be a corrupting influence on the other students.
So the school would simply remove her, arguing that her presence was a disruption.
Her entire future, her fundamental right to a basic high school education, could be erased overnight.
The school didn't provide tutoring. They didn't offer a leave of absence. They just expelled you.
The formal education of thousands of young women ended abruptly, which of course permanently limited their earning potential and future prospects.
But the regulatory framework of Title IX changed this reality mechanically and decisively.
If we connect this to the bigger picture, while the 37 words of the statute are brief, the law instructed federal agencies to write the specific regulations for enforcement.
Right, the nitty-gritty rules.
Exactly. In 1975, the Department of Health, Education, and Welfare issued the final Title IX regulations, and they explicitly addressed this issue. They prohibited discrimination on the basis of pregnancy, childbirth, false pregnancy, termination of pregnancy, or recovery therefrom.
So they reclassified pregnancy. Instead of treating it as a moral failing that required expulsion, the federal regulations required schools to treat pregnancy like any other temporary medical condition.
This reclassification was revolutionary. It required schools to provide pregnant and parenting students with equal access to educational programs.
And it mandated reasonable accommodations, right?
Yes, excusing absences for medical needs related to the pregnancy and ensuring the student could return to the exact same academic and extracurricular status they held before the leave.
A school could no longer force a pregnant student into a subpar, segregated continuation school against her will.
And education was transformed from a conditional privilege into a federally protected right.
And we have to remember the exact phrasing of the law again. Title IX applies to any education program or activity receiving federal money. It doesn't just say students.
That phrasing is the linchpin for the entire ecosystem of the university. It protects the people at the desks, yes, but also the people standing at the chalkboard.
Which ties right back to Bernice Sandler and her original complaints about universities denying women tenure. Title IX secured the front of the classroom as well as the desks.
It protected teachers, professors, and administrative applicants from sex discrimination in hiring, promotion, and pay.
Was there pushback on that? I imagine schools didn't just give up their hiring practices willingly.
Oh, there was actually a significant legal battle over this specific interpretation. Some school boards argued that Title IX only applied to students, not employees.
Attempting to preserve their discriminatory hiring practices?
Exactly. This fight went all the way to the Supreme Court in a 1982 case, North Haven Board of Education v. Bell, and the court definitively ruled that Title IX does, in fact, protect employees from sex discrimination in federally funded educational programs.
So you could no longer fire a female high school teacher simply because she became pregnant, which used to be a standard clause in teaching contracts.
It was written right into the contract. You get pregnant, you lose your job.
Insane. And you couldn't systematically pay a female professor less than a male colleague for the exact same workload.
By protecting the women at the front of the classroom, Title IX fundamentally altered the academic environment. It ensured that the young women sitting at the desks actually had role models in positions of intellectual authority.
The professional ceiling was basically dismantled right before their eyes.
So when you outlaw early vocational tracking, halt the routine expulsions of pregnant students, ban sex-based admissions quotas, and protect female faculty,
You set the mechanical gears in motion for a massive demographic shift.
the enrollment flip that follows in the subsequent decades is where you can truly measure the kinetic energy of this legislation.
So what does this all mean? Let's lay out the data on this enrollment flip, because the sheer scale of the demographic inversion is staggering. We discussed how medical schools were hovering around 9% women in 1970.
The quota wall was holding firm.
Firm. But once Title IX removed the legal cover for those quotas, the dam broke. Fast forward to 2019, and for the very first time in American history, women became the majority of U.S. medical students.
Hitting 50.5%.
And by the 2023 to 2024 academic year, women made up 54.6% of total U.S. medical school enrollment.
It is a total demographic inversion in half a century, and the trajectory in the legal profession mirrors it almost perfectly.
Right. Law schools were also sitting at roughly 9% women in 1970. In 2016, women became the majority of students at American Bar Association accredited law schools, hitting 50.3%.
And by 2023, they were at about 56%.
The symmetry with Patsy Mink's story is incredible. She received a dozen rejection letters from medical schools explicitly because she was a woman. She went to Congress, drafted the legislative vehicle to destroy those quotas, and 50 years later.
Women aren't just gaining entry into those medical schools. They are the clear, undeniable majority.
It is the ultimate systemic vindication.
It really is. But we must look at what this enrollment flip actually means for society at large. How do we conceptualize a shift on this scale? We aren't just talking about a couple of prestige professions.
No, women now earn the majority of degrees at absolutely every level of higher education.
Every level. Roughly 58% of bachelor's degrees.
Wow.
63% of master's degrees, and 56% of doctoral and professional degrees are earned by women.
For you listening, you have to conceptualize it as a total reorganization of who holds the intellectual and professional capital in the United States.
Because in the pre-1972 system, authority and specialized knowledge were legally and culturally hoarded by men. The 1975 Title IX regulations fundamentally broke that monopoly.
The pipeline effect is profound. When you change who gets the medical degree, you eventually change who runs the hospital.
You change the research priorities of the entire medical field. For instance, the historically neglected area of women's health research gains funding and attention. Why? Because the people writing the grant proposals and directing the laboratories have different lived experiences.
Right. And when you change who gets the law degree, you change who argues before the appellate courts. You change who becomes a judge, who drafts the legislation, and who shapes the jurisprudence of the country.
The scale of women earning degrees is not just a triumph of educational access. It is a profound realignment of the structural power in America.
Okay, but as much as the data demonstrates this incredible triumphant flip in medicine, law, and the biological sciences, the data also reveals a very stark, persistent contradiction.
We have to address the unfinished half of this revolution.
Exactly. If Title IX so thoroughly transformed these powerful professions, why did the revolution stall so dramatically in the technical fields?
The STEM gaps.
The statistics in STEM science, technology, engineering, and mathematics are sobering, and they present a massive puzzle. Despite women dominating higher education overall, as of 2021, women earned only about 18% of computer science bachelor's degrees.
18%.
Engineering, physics, and computer science remain stubbornly, overwhelmingly male-dominated. We were talking about the fields with the absolute lowest female degree shares across all of science and engineering.
The needle has barely moved in some of these specific disciplines over the last 3 decades. In fact, in some subfields of computer science, the percentage of women actually decreased from its peak in the 1980s.
Decreased. We have to ask why. The legal architecture is identical. Title IX applies to a university's engineering department and its computer science labs just as much as it applies to its medical school and its law school.
The past 7 words do not contain an exemption for physics.
Exactly. Legally, there is no distinction. So why the difference?
Well, historically, the federal enforcement of Title IX in STEM education has been famously weak and reactive.
Reactive, meaning they wait for a complaint rather than investigating proactively.
Yes. The Department of Education's Office for Civil Rights aggressively pursued sports equality because it was highly visible. And they cracked down on the overt admissions quotas in law and medicine.
Because quotas are easy to prove on paper.
Right. But they did not historically bring that same proactive enforcement and like conducting systemic compliance reviews to the engineering and physics departments.
But let me push back on that for a second. If the exact same law governs a university's medical school and its engineering department, is the low participation in STEM truly just a failure of weak federal enforcement? Or is it a deeper, much more complicated cultural pipeline issue that a piece of civil rights legislation simply cannot reach?
That raises an important question. Can a federal law actually force a cultural shift in how we socialize middle schoolers around math and computers?
Yeah, that's what I'm wondering.
And that tension is the core of the ongoing debate among sociologists and policymakers. It is undoubtedly an intersection of both legal enforcement mandates and deeply entrenched, diffuse academic cultures.
Let's contrast the integration of medical schools with the persistent gaps in engineering to make sense of this.
Okay, in medicine, the primary barrier before 1972 was an explicit quota at the point of admission. It was a locked door.
Physical barrier.
Once Title IX made that locked door illegal, the dam broke because the interest in the pipeline of qualified women already existed waiting outside.
The bottleneck in medicine was centralized at the admissions committee. You change the rule for the committee, you fix the bottleneck.
But in engineering and computer science, the barriers are diffuse, cumulative, and largely cultural. They involve what researchers call the leaky pipeline.
The leaky pipeline. Okay, break that down for us.
This pipeline doesn't start at college admissions. It starts in elementary school. It involves subtle biases in how teachers evaluate math skills, the way computing is marketed as a male-centric hobby.
Video games, coding camps aimed at boys.
Exactly, and the societal messaging regarding who looks like a natural engineer.
So by the time these students reach the university level, the culture of those specific STEM departments can often be alienating.
It might lack mentorship for women. Or The pedagogical approach in introductory weed-out classes might heavily favor students who had prior informal socialization in coding or robotics, which, as we just said, leans heavily male.
So a law like Title IX is highly effective at mandating equal access. You cannot legally bar a woman from enrolling in an engineering program.
But civil rights legislation struggles to mandate a welcoming culture or to retroactively fix the societal messaging a young woman received for 18 years before she set foot on campus.
It is very difficult for a federal compliance review to quantify and penalize an unwelcoming lab environment compared to a blatant admissions quota.
The law provided the legal mechanism to break down the locked door, but it is not necessarily the right tool to change the atmospheric pressure inside the room once the door is open.
That is a perfect way to put it, the atmospheric pressure.
And the historical lack of robust, proactive federal compliance reviews, specifically targeting STEM departments, meant that those cultural barriers were rarely scrutinized through a legal lens.
The institutions were rarely forced to deeply interrogate why their pipeline was leaking so severely.
Nicely.
And this uneven success in the technical fields brings us directly to the modern and highly contested paradox of the Title IX era.
The massive disconnect between educational attainment and workplace reality.
The degrees versus pay paradox. For you listening, we want to map out the reality of this paradox. Women now hold the vast, overwhelming majority of college degrees at every single level in this country. They have the credentials.
They absolutely do.
But significant pay gaps, wealth gaps, and leadership gaps persist in the broader society. The credentials flipped, but the economic and structural outcomes only partly followed.
This paradox forces us to evaluate the ultimate efficacy of the law. If the goal was educational access, it succeeded wildly. If the goal was broad economic equality, the results are deeply complicated.
There is a very live, highly nuanced debate about how to interpret this reality, and it centers on labor market economics versus the scope of educational law. We want to outline this debate carefully and neutrally, because brilliant economists, sociologists, and legal scholars disagree on the root causes and the solutions.
Let's look at one perspective. We'll call it Perspective A. Some argue that Title IX was a resounding, unmitigated success because it achieved exactly what it was drafted to do. It ensured equal access to federally funded education.
It removed the legal barriers, ended the quotas, ended the vocational tracking, and gave women the degrees.
According to this view, the educational law did its job perfectly. The persistent pay gaps are not a failure of Title IX, but a failure of the broader labor market and corporate structures to adapt to a new workforce reality.
So the argument here points to structural rigidities in the workplace.
Things like the lack of affordable childcare, inadequate family leave policies, and the labor economics of what researchers call greedy jobs.
Greedy jobs, what does that mean?
These are high-paying professions, like corporate law or high finance, that demand unpredictable, extremely long hours. And those hours disproportionately penalize anyone with primary caregiving responsibilities.
Which still disproportionately falls on women. So from this perspective, the classroom was the victory condition, and the corporate boardroom is an entirely separate battlefield that requires a different set of legislative and cultural tools.
The education system delivered the human capital, but the labor market failed to properly value it.
Okay, I understand that. But then you have perspective B, which challenges that narrative completely.
Yes, others argue that constantly touting the majority of degrees statistic actually masks the reality of the situation. It overstates the true level of equality achieved.
They note that true equity hasn't been achieved if the economic and leadership outcomes don't match the credentials.
If you possess 63% of the master's degrees, but you still do not make up the majority of CEOs, partners at major law firms, or chief of surgery roles,
then the systemic bias didn't disappear. It just mutated and moved further down the pipeline.
Exactly. According to this view, celebrating the degree statistics without addressing the occupational segregation and the leadership ceilings is a hollow victory.
And nested deeply within this debate is the attribution question.
How much credit does Title IX actually deserve for the massive credential flip?
Right. How much of this was the law and how much was the changing world?
Historians and economists debate the exact ratio all the time. How much of the massive increase in female college enrollment is strictly due to the enforcement of Title IX versus the broader cultural momentum of the women's movement in the 1970s?
Or how much is attributable to the introduction and widespread availability of the birth control pill, which allowed women to delay marriage and heavily invest in long-term professional education?
And how much is due to the shifting modern economy, where the financial return on a college degree skyrocketed, making higher education an economic necessity for middle-class survival.
Most impartial analysts will tell you that Title IX was the necessary legal mechanism. It dismantled the hard bureaucratic barriers like the admissions quotas and the pregnancy expulsions. It provided the legal framework.
But it also rode a much larger, complex societal and economic wave that it did not single-handedly create. It opened the floodgates, but broader societal shifts provided the water.
The law provided the channel for the momentum to flow through. And the interpretation of what constitutes sex discrimination under this law is not settled history. It is a living, breathing framework that is actively being argued in federal courts today, shaping everything from campus administrative policies to workplace compliance training.
For you listening, it is vital to realize that this debate isn't just an academic exercise. This paradox actively shapes the policies of the universities your children will attend.
It dictates the structural reality of the workplaces you navigate every day. So bring our deep dive to a close. Let's look back at the incredible multi-layered journey we've mapped out.
We started with the deeply personal grievance of Patsy Mink, staring at a stack of medical school rejection letters that cited her gender as a disqualifying factor.
We traced how she, alongside strategists like Bernice Sandler discovering the hidden leverage in federal contracting, and Edith Green orchestrating methodical congressional hearings, weaponized that grievance into a federal statute.
They drafted the legal machinery that dismantled the rigid, state-sponsored vocational tracking of shop class versus home economics.
They forced the creation of administrative regulations that ended the cruel, routine expulsion of pregnant high school students, transforming education from a conditional privilege into a protected right.
And those actions ultimately catalyzed a generational demographic flip, transforming American medicine and law from spaces with strict 9% quotas to professions where women now hold the majority of the seats.
All while we must acknowledge the stubborn, unresolved reality of the leaky pipeline in STEM and the complex labor market forces that complicate the narrative of pure victory.
That unresolved 18% figure in computer science is where we want to leave you with a final thought to mull over as you step back into your day.
It really makes you think about the future.
Consider the trajectory of the modern world. We are currently rushing headlong into an era defined by artificial intelligence, complex algorithms, and automated digital infrastructure.
These systems are going to dictate our finances, our healthcare diagnostics, our legal systems, and the fundamental architecture of our daily lives.
But these systems are primarily being built and trained by the fields with the lowest female degree shares: computer science and engineering.
If the classroom revolution sparked by Title IX remains unfinished in the very subjects that are inventing our future, how might tomorrow's technology inherently reflect the blind spots of an educational gap we never fully closed?
That is the question we have to answer.
Think about your doctor, your lawyer, the architect of your building, and the engineers writing the code for your future. Who gets the credential to build the world truly matters. Thank you so much for joining us on this deep dive into the hidden architecture of American education. We encourage you to look closer at the invisible rules that shaped your own educational journey. We'll see you next time.